Hey everybody, this is Chris Addick from the Veterans Law Blog, and I'm coming to you today to talk to you about the Appeals Modernization Act, also known as AMA, also known as the Modernized Appeal Process, also known as the new Charlie Foxtrot that the VA has come up with to screw up our claims, delay, and backlog them. That last one is the pessimistic view of things, as you can tell. But in any event, um, the basic things that you need to know about the AMA, we're going to cover them in this short video in just 1 second. Hey, welcome back, everybody. What we're going to talk about today, again, is the Appeals Modernization Act, the AMA, the Modernized Appeal Process. On the blog, we're going to keep it simple, and we're going to call it the AMA, or the Modernized Appeal Process. It was passed into law February 19th, 2009. A lot of people argue of whether it was Trump that did it or Obama that did it. And so I'm going to settle that bet if you have a bet with your drinking buddies. It was started into, the process was started under the Obama administration, and it was signed into law under the Trump administration. So it was going to get passed either which way you look at it. I don't think either president gets to take credit for it. But frankly, they both can take the blame for it, though, if it goes south. But in any event, February 19th, 2019, that's the big day, because after that day, any ratings decisions the VA issues are in the AMA, or Modernized Appeal Process. There is no longer a legacy process. The old way of doing things is no longer available if you get a ratings decision after February 19th, 2009. So what else? What are you going to be able to do if you do get that ratings decision? What are your options here under the AMA? You've got three options. And then the third option has three options. So the bottom line, the very first thing that you can do if you get a ratings decision from the VA that you do not like or that you disagree with, the first thing that you can do is you can seek what's called higher level review, or HLR, some people are calling it. It's not exactly an acronym that flows off the tongue, but we're going to call it the higher level review. You cannot add evidence in a higher level review process. The senior rater, who probably used to be a DRO under the system, that's the only part of the old system I really liked, but the higher level review officer is going to look at the record as it existed on the day of the ratings decision. So you can't add new evidence. If you add new evidence, they're not going to consider it. But they're going to take a look, and they're going to see if the lower rater made a mistake. If so, they have the ability to reverse and fix that decision. The duty to assist does not apply in the higher level review process. So that's the first option that you have. By the way, we're talking about all these different options. You can hop on the Veterans Law Blog and see more information about them in our posts there. So that's the first option, higher level review. The second option is the supplemental claims process. And what that is, you can consider it's very much like the claim to reopen concept that was under the old legacy system, with some significant differences. So basically, you file a supplemental claim within 1 year of a VA ratings decision, and you have to attach new and relevant evidence. Now, if you remember, under the claim to reopen, it was new and material evidence. It's new and relevant evidence. Now, the VA, there's something in there in the statute that says that Congress wants new and relevant to be considered the same way as new and material evidence, but I'll tell you, those two terms are dramatically different to lawyers, and it's going to get somewhere down the road, and that's probably not going to hold up, but we'll see. For right now, it's being interpreted as the same thing. So if you have new and relevant evidence, file it with your supplemental claim form. And as long as you do so within 1 year of that VA ratings decision, you will keep the original claim date or the original notice of intent to file date as your effective date. So that's another way, and you're going to file that on VA Form 20-0995. You can also claim increased ratings using that form, and you can also, frankly, well, TDIU is an increased rating, and you're also going to file a separate form with it, but that's how you would trigger the increased rating based on unemployability, is with a supplemental claim form. Now, the supplemental claim lane, the second lane of the three lanes that you have after getting a ratings decision you disagree with, this is the only one where the duty to assist still applies, where the VA still has to help you to obtain the information necessary to substantiate your claim. So that's the second way. The third way is an appeal to the BVA. Now, it used to be that you had to go through all those hoops, the tennis match back and forth, the supplemental statement of case, VA 9, all that stuff doesn't exist anymore. It's all gone, out the window, bye. Now, basically, all you have to do if you want to appeal to the BVA is you have to fill out a notice of disagreement form. Now, that can be deceiving, because those old notice of disagreement forms that the VA was so adamant that we start using, they're worthless now. Don't use them. They're going to ignore them. They're not going to pay attention to them. So do not use the old pre-February 2019 notice of disagreement forms. What you are looking for when you're appealing to the BVA. I got to look this up every single time because I'm not used to these numbers, but the VA form 10182 is a BVA appeal, a notice of disagreement form. And you're going to go ahead and you're going to file that with the board. Fill out all the information on that form. I'll tell you one thing we've been seeing from a lot of attorneys saying that unless they copy the exact specific issue as it appears in the ratings decision, that the board is pretending not to see it. Now, I haven't verified that that's true, but it may be something you want to consider doing. So, in any event, once you appeal to the BVA, there's 3 dockets that you can go into. And a docket is just lawyer speak for the list of cases that a particular judge or a court has to hear. And so the first docket is called the no evidence, no hearing docket. So maybe we can call that the rocket docket. I guess that's the idea behind it, is that appeals are supposed to fly through this one because the veteran's not adding any kind of evidence. They're not having any sort of hearing, and so it's straight and it's clean. It's much like a higher level review, except it's being done by a BVA judge. So you're probably going to use this most commonly when you have an issue of law that you need to challenge through the BVA and probably up to the Veterans Court. The second docket is the evidence docket. And you can submit evidence within 90 days. You can supplement your record within 90 days of filing your notice of disagreement with any evidence that you want the board to consider. And the third docket is the hearing docket. And now you can request a hearing, and then you have up to 90 days after the hearing to submit new and evidence. So in theory, that hearing docket is supposed to be the slowest because you've actually got to get a board judge to hear the case. I do know that the VA is working on some, or the BVA, I'm sorry, is working on some pilot programs where they're going to start doing teleconference board hearings. And I know the pilot program for that is testing out to see whether they can be done from your attorney's office or in some cases probably from your own computer in your own home. So we'll see how that goes. It's kind of a creative concept. We'll see if it actually works. There's a lot of wrinkles in it. But those are the 3 dockets. You've got the no evidence, no hearing. You've got the evidence docket, and you've got the hearing docket. Now, what happens if you get a BVA decision that you don't like? You can still appeal to the Veterans Court. Those timelines do not change. You can also file a supplemental claim if you file within a certain time frame. I believe it's 1 year from the BVA decision as well. I'm going to have to double check that. But if you file that supplemental claim after the BVA decision, then you, in theory, will also keep your effective date so long as you include new and relevant evidence. So you can kind of see how this process is being used to kind of split up the different types of appeals so that they can be handled and triaged in a different way. In theory, it's a good idea. We'll see in practice if it actually works, because there are a lot of glitches going on behind the scenes. So in any event, one thing I want you to be careful of is that this system has only been in effect since February 2019, and it really is like playing chess on a 3-dimensional chessboard to try to figure out your strategy. So if you're talking to somebody that says they absolutely know that the best way to do something under AMA, you can go ahead and plug your ears up, because they're full of shit. Nobody knows. Nobody has any idea. The best that you can do is gather as much information as you can and make the best decision that you can make at the time. And see, as things pass, as time passes, we're going to get more and more information about how this works. But right now, it's just a crapshoot at this point. So make sure that you double check what you're doing. That way you don't miss deadlines.